everyone. Welcome, everyone. I think a few people are still coming in, but I want to get started because we are not only an Eye on Africa today, we're also a class. And we always tell our students come on time, and we want to start on time because we know you have other classes to get to. I'm Jamie Monson. I'm the director of the African Studies Center here at Michigan State University, and it's my very great honor and pleasure to be able to introduce today's Eye on Africa speaker, Justice Albi Sachs. Albi Sachs is a freedom fighter. He's devoted his life to the struggle for liberation in South Africa, to human rights activism, and to the drafting and now the defending of the democratic constitution of South Africa. Albi Sachs is a jurist. He was appointed by President Nelson Mandela to South Africa's new constitutional court, for which he participated actively in the negotiations. After 1994, he became known all around the world for his commitment to rights, individual rights to equality, and to dignity under the law. We were so fortunate to have him here in June 2018 when he received an honorary Doctor of Law from the MSU College of Law in June. I want to thank Nicholas Mercuro, who's here, for being really a leader in bringing Judge Sachs for that degree and also now to be teaching here on our campus. He's back with us again, so warmly welcome, teaching a unique one-credit course, a very creative course in the College of Law. The title of the course is From Jailbird to Justice, Reflections on Law, Oppression, and Emancipation, and the members of that course are here, so you're warmly welcome here. And we're so lucky that our Eye on Africa serves as one class or one part of that course, so all of us get to be your students today, Justice Sachs. It's just a wonderful opportunity. I'd also like to let everyone know that there will be a lovely reception tomorrow afternoon from 3:45 to 5:15 in the law school boardroom that's on the third floor, together with an exhibition of photographs from South Africa by photographer Leonard Freed. So please do join us there as well. There will be more opportunity for mingling, talking, and discussing than we have time for in today's event. So without any more ado, I would like to then welcome you all. The topic of today's class, today's Eye on Africa, is same-sex marriage in the Constitutional Court of South Africa and the U.S. Supreme Court. Welcome, Justice Sachs.
I was introduced yesterday at Wayne State, and the introducer said, without any more ado. I said, what is this ado? Does anybody know? I know what the phrase means, but without more ado? Does the word have an existence outside of that particular?
Yeah, much ado about nothing.
Okay, that's two ados. Okay, so it doesn't only exist when it's without. It can be too much. Okay, 1991, November, I'm driving on a beautiful coastal road towards the center of Cape Town, and I'm sweating. I'm sweating because November is our summer in the south, it's 80 degrees. I'm sweating because I'm driving with my left. I've lost my arm in bomb blast 3 years earlier. South African security agents put in my car, and I've been exiled in Mozambique. I'm not used to driving. I'm sweating because I've been in exile for 24 years, and I'm not all that familiar with the roads of Cape Town. But above all, I'm sweating because I'm going to go for the first time on a gay pride march. Oh, thank myself. If only they had a poster that said, "Straights for gays." Then I feel ashamed of myself. I'm going on the march, and yet I'm embarrassed of going on the march. I drive. I'm a bit late. I know they think he promised to sign up, but he's backing out. And I see them marching towards me through the streets of Cape Town. The first poster I see, it says, "Suck, don't swallow." Oh my God. I'm going to be in the newspaper tomorrow for sure underneath that poster. Anyway, I find some parking. I hobble along. I was a bit weaker then than I am now. It's only 3 years after the bomb. And I joined the march. And I marched next to then Professor Edwin Cameron, very famous South African judge, then a leader in the gay liberation movement, presently a judge on the Constitutional Court of South Africa. Openly gay and openly living the patriarchy. And I'm marching next to him and I feel proud. I feel fantastic. I feel I've crossed over a barrier of awkwardness in the past. But I'm marching alongside people who are fighting for the dignity of their rights. And we stop at a park not too far away. They asked me to say a few words, and just from pouring out, we tried for, then we simply spoke about gay rights. In South Africa, it's important for a section of our community that's been subjected to gross discrimination. But it's got a much greater importance than that. It's the right to be different, the right to be who you are. If we can't manage difference in South Africa, we finish as a country. It becomes a touchstone of the capacity of our new emerging nation to manage difference. Difference was used for oppression, dispossession, exclusion. Now, can we live in a country where we are different in all sorts of ways? Language, culture, religion, faith, taste, interests, personalities, in a way where difference is not used as an instrument, as a club, to keep other people down. And that's November 1991. Fast forward to April 2004, 2005. I'm now Justice Albi Sachs, and people can call me Albi, by the way, or that's too much, Judge Albi. I'm not sitting as a justice now, I'm just me. And we're sitting around the conference table, and the Chief Justice Pius Langa says, he's received a request from Christian Lawyers for Africa for him to attend a conference they're having near Johannesburg. It will be in April, and when the court is in recess, he was actually going to Fiji to help with constitutional negotiations there. Is there anybody amongst the judges who will be around who can greet the conference on behalf of the Constitutional Court? He can't go. He'd been invited. So I put up my hand. Very tentatively, Pius, I say, I'll be on court recess duty. I don't think I'm the right person to go to that conference. I'll be exactly the right person. And I know what he means. He's Christian, he's a lawyer from Africa. If he goes, it's an identification, a sectarian identification. If I go, I'm Jewish, I'm a Jew, I'm secular, I'm from Africa. Then I'm representing the court. And it's not a personal connection with that body. Identification, a sectarian identification. If I go, and a few weeks later, I'm now not driving, I'm being driven. April is a coolish month in the evening in Johannesburg, I'm not sweating. But I'm feeling a bit uncomfortable. What am I going to say? And I can say on behalf of the Constitutional Court of South Africa, welcome to our country, have a good conference. That's saying nothing. That's not actually saying anything. It's allowing words to come out, polite words that are good. And we are a court of conscience. We are a people of conscience. And surely I can say something that connects with them in a more meaningful way. So I've got 5 minutes, and I tell them about the problem I had when it came to taking the oath when we were sworn in front of Nelson Mandela. And you can raise your right arm and say, "So help me God," or you can affirm. And I grew up in a home that my parents had fought their parents on religion being imposed upon them. I grew up with my own conscience. And I grew up, and I'm telling this to the people there, feeling for me to offer a prayer or make a statement which I don't believe in would be disrespectful to me and disrespectful to God if God exists. And that's quite tough for a 12-year-old. But it was very important for me. And now it comes to taking the oath of office to be sworn in as a judge. But I want to raise my right arm. It's the arm of struggle, of sacrifice of all my comrades who died. And I'm not sure what to do. And I was what I called alphabetically challenged. Sachs, I came last. So I'm hearing my colleagues, most swear so help me God, a couple affirmed. And I said, and I raised my right arm and I said, so help me God. This was the oath that I wanted to make. Welcome to the South Africa Have a Good Conference. They stood up and they cheered. And after the break that we had, they said they'd like to visit the court. So the next day, about 70 of them come to the court. I take them on a tour. We built the court right in the heart of the old Fort prison, where Gandhi and Mandela were locked up. No one else in the world can say we locked up both Gandhi and Mandela. We South Africans can make that case. And for those who know, also Chief Albert Lutuli and Winnie Mandela and Robert Sobukwe of the AC, many others were locked up there. It's a beautiful building. And 70 of them come. I take them around. People are entranced. Ruth Bader Ginsburg said it's the most beautiful courthouse she's seen anywhere in the world. And I look at my watch and I'm late. I've got a meeting at the women's jail where the Commission for Gender Equality now has its headquarters. So I say, thank you very much. And I say, please don't rush away. We have to say a prayer. Now some prayers are quick and short. Some prayers go around the world a few times. This one went around the world a few times. And they're offering me that prayer. I'm secular. But they're offering it with love, and I'm receiving it with love. I understand the intention. And now I'm about to rush off, and I say, let us lay on hands. So simply pair of hands, relieving hands on my secular body. It takes time. But they were giving what they wanted to give, and I could receive it in the way that they gave it. It was a very, very beautiful moment. Now, why am I telling you these two stories? Because later in that same year, it's the same Albi Sachs. We've been on the Gay Pride March. We've received the hands of Christian lawyers on his body. He's sitting in the Constitutional Court of South Africa to determine whether same-sex couples are constitutionally entitled to marry. So that's the setting, the background. In the opinion that I wrote for the court, I just opened with the statement, I forget their names now, Maria, somebody, and Helena somebody, and I didn't say the names. I said 2 people met, were attracted to each other, went out together, decided to set up home together, and after living together for 10 years, decided they wished to marry, to give a public signification to their relationship. And they went to the marriage officer, and he said, I'm sorry, I can't marry you because you're both women. They went to a lawyer. The lawyer went straight away to court. Very simple argument. They're being denied fundamental rights. And our Bill of Rights, our Constitution, includes, amongst the grounds of difference or identity, if distinctions are made, there's a presumption of unfairness. The forbidden grounds of unfair discrimination: race, color, creed, national origin, birth, disability, sexual orientation is included there. So it's a powerful textual statement that was made by the drafters of our Constitution. The drafters were the parliament that had been elected democratically, overwhelmingly black, overwhelmingly from poor backgrounds. And they had put sexual orientation together with about 15 other grounds on which discrimination would be presumptively unfair. And he bases it simply on that. The Marriage Act says, the marriage vow, I, A.B., take you, C.D., to be my lawful wedded wife, stroke husband. And the marriage officer says, you're not a wife, you're not wives, you're not husbands. These are gendered terms, and I can't marry you. What was interesting for me was to see the lawyer who represented them in our court was an elderly white Afrikaner. Now, there are a number of white Afrikaners who were in the freedom struggle. We call them comrade. But this guy wasn't like them at all. His whole body language was like one saw in the films about the civil rights struggle, if you like, a racist from the South, in his style and his manner of talking and speak everything. And he was saying, justices, my case is a very simple one. All we're saying is it would be unfair to stop them from getting married. Meanwhile, the Equality Project, I think it was LG when we started, by then it was LGBTQI, I think. Very careful, planning, doing their research, and they are taking the case through the courts. They get up to the Supreme Court of Appeal, the one below us. They get a decision where one judge, in fact it was Justice Cameron, said that the Marriage Act allows religious personalities who are identified as marriage officers by the state to celebrate marriages. I don't know if it's the same in the US, that your marriage can be celebrated in a church, in a synagogue. It's recorded, and you don't have to go afterwards to the state to copy it. It automatically, if the people have been designated as marriage officers, then they have the power to solemnize the marriage. And he said there's one church at that stage that was permitting same-sex couples to marry. And that somehow should be read in to the Michigan statute. That's very tiny, very small kind of possibility. And so now we're arguing. The state is a bit equivocal, and we want to get argument. We want to give it a good decision. And if everybody in the court is going one way, you're not necessarily dealing with all the difficulties. A body called Wasn't Christian Noise for Africa, it was they call themselves a family-oriented body, intervened as amici. In our jurisdiction, an amicus can intervene through written documents and can apply to be heard as counsel in oral argument if they've got something to add above what's already in the documents and the pleadings. And so this conservative, I think it's Catholic Church-sponsored body intervenes, and given the text of our Constitution, they can't say same-sex relationships are an abomination in our eyes, they shouldn't get any support from the state. So the argument is basically, we can recognize the unions of same-sex couples under the Constitution, whether we like them or not. They're entitled to that. They can regulate their tenancy arrangements, they can regulate visitation rights. As equivalent to spouses. They can regulate inheritance rights. That can all be regulated. But don't call it marriage. The case became about the M word, marriage. Now my colleagues are wondering now, what's Albi going to do? I've been asked to write the lead opinion. We had a case previously on the rights of cohabitant survivors who weren't married. And we had a Surviving Spouses Marriage Act that allowed a surviving spouse who'd been disinherited by the deceased person in a will to get at least maintenance from the estate. But it didn't provide that same support for cohabitants. And the case was brought to say this was unfair discrimination on grounds of marital status. And I agreed. And I wrote a dissenting opinion, which was twice as long as the main opinion, saying that there are some marriages that are just empty shells, just a piece of paper, and there's some relationships of cohabitation where it's usually the woman has invested her life in the family. She's born and brought up the children, she's looked after the home, she's cared for the deceased when he was elderly and ill. So if this is a question of marriage law, okay, she's out. If it's a question of family law, and the interest that the Constitution wants to protect, the intimacy, the involvement, the connection, then it would be unfair discrimination in cases like that to exclude her. Sadly, my colleagues by majority went against me. But I've spoken quite strongly about marriage can be only a piece of paper. And now what's Albi going to say? That marriage isn't only a piece of paper. If it's only a piece of paper, what are the gay couples and lesbian couples worried about? They can protect all their legal claims and rights. So the meaning of marriage, the symbolism of marriage, the cultural significance of it became very central to that case. And also the issue of why not say, we believe in marriage, it's fantastic, more people want to marry. And accept the solemnity, accept the commitment, accept the responsibilities that go with the public sharing of their love and intimacy. Unless the assumption is that somehow, if same-sex couples can marry, that's going to tarnish the very notion of marriage. And I think that was clearly in the minds of the people opposing, even if they wouldn't say so in terms. And what could be more hurtful, more abrasive of the dignity of the same-sex couples than to say you can't share the same public recognition that heterosexual couples have, because that will somehow contaminate marriage as we know it. Amongst the arguments being advanced was one that was said to be based on, in support of that position, on international law. They said if you look at, I think it's the Universal Declaration of Human Rights, it says every man and woman has the right to marry and set up a family. It says every man and woman. That's international law. And a section of my decision that I worked on very, very hard, and nobody's picked up, so I'm mentioning it to you in case somebody here would like to be kind to me, was the way international law evolves. This was 1948. The purpose of that provision in 1948, in fact, was to give equal rights to women. That's why it was put in. The purpose wasn't to exclude same-sex couples, every man and woman. It was expressly to mention women, not to say everyone, or as many documents said in those days, every man has the right to marry, every man and woman. That's the purpose then. But if we look at the way the horizon of human rights has expanded over the years, dealing with the rights of women, there was the phrase, the rule of thumb. You familiar with the rule of thumb? I think people in the women's movement will remember. That term rule of thumb in general language means rough, more or less. In terms of the English common law, which is applied in the United States, men were allowed to chastise their wives using a rod that would be no thicker than a thumb. That was the rule of thumb. It wasn't so many inches, millimeters, the rule of thumb. And that was into the 20th century. And patriarchal values were accepted as part and parcel of the common law, the ordinary law. How much that has changed over the years. When you think of labor rights, workers were being sent to jail for conspiracy to destroy the commercial interests of the employers under the common law. It's conspiracy to interfere with economic rights of the owners. That changed dramatically over the years. Environmental rights weren't even considered in those days. So one has to look at international law and international protection and respect for human rights in terms of the evolution. And now respect for the love and intimacy and rights of same-sex couples has now reached the stage where it's clamoring for recognition. One has to see all these things in evolving terms. There were other examples of things that were taken for granted 50, 60 years before, and now are seen as totally intolerable. The question of the relationship between the sacred and the secular was, for me, central to this particular case. That's really what it was about. And apart from the homophobia, which is fairly widespread in our culture, it would be quite intense when supported by doctrine in a number of faith communities. And a certain advocate counsel by the name of Smythe, he represented, it was called the Family Alliance. And he quoted from scripture to show that same-sex relationships were an abomination. That's what he said. And he said, my rights to religious freedom are being invaded by the state now recognizing something that trenches upon, infringes, violates my fundamental principles and beliefs. And the whole core part of my opinion, the judgment, is devoted to the relationship between the sacred and the secular. And maybe this is where, in background, my experiences of the march and the laying on of hands, they're not conscious in my head, but I'm wanting to speak to the whole nation. Not to the Victoria side, civil rights, more freedom, humanity, enlightenment, and get rid of the bigotry and the backwardness and homophobia of the others. I think it's unfortunate if the court ends up taking decisions in a cultural war that have the effect of dividing the nation. And then judges are appointed in terms of which side are they on, in terms of the culture dying. And somehow our constitution should speak to everybody. And I, as a secular person, can acknowledge honestly and openly and profoundly the importance of religion, not just as a right that people have in private to follow their beliefs, or in communion with others to follow their beliefs. It has an enormous impact on public life. It's present in many spaces and areas. It's part of the culture, the temper of our people. And I can say that because I'm not proselytizing. I'm not trying to advance religious belief. I'm secular. But I recognize that as a reality. When it came to the preamble to our Constitution, a man called Michael Cassidy flew down from Durban early on in our negotiations. He said, Professor Sachs, would you like to be a hero to millions? So that's quite a nice opening. He said, we will welcome democracy in South Africa, the end of racism. And I have 1 million people in my particular church, and millions others feel the same way. But please start the Constitution with the words, in humble submission to Almighty God. We don't want to see the Constitution as something separate from our beliefs. And I think, no, we can't start with that. It gives an imprimatur, a characterization to the whole document that infuses it with a deep, profound religious significance. And yet I'm moved by the fact that he will welcome democracy if he feels democracy is not cold, sterile, the way he sees it, godless. So I was the one who came up with the suggestion, Nkosi Sikeleli Africa. Nkosi Sikeleli Africa, Malupa Kumisa Ponduwa, God bless Africa. And we would sing it in a struggle. Believers and non-believers alike, we would raise our fists. And it united us. It was the hymn of the oppressed. So that was my suggestion there, that the invocation of the Lord would be meaningful, extremely meaningful to people like Michael Cassidy, and it would not be harmful to people like me because of its historical significance. So now I'm trying to tell the story, and I don't root it in international jurisprudence. At that stage there wasn't much support. Margaret Marshall, Chief Justice of Massachusetts, was the only American judge at that stage who supported same-sex marriage by 3-2 majority in the Massachusetts Supreme Court. Canadian jurisprudence was going in that direction, and lots of state courts, Supreme Courts in the United States going against it. But it wasn't simply a lack of majority support. I didn't want our people to feel we are copying something from America. And I stress the fact that families in Africa and South Africa take many different forms. This idea of the simple nuclear family, mom and dad, and 2.5 kids, defies the reality of single-parent families, families run by grandparents, extended families, and so this would be another version, if you like, another development of a family formation in Africa that people could understand. Yes, yes. I was able to point to jurisprudence in our court where we had decriminalized sodomy, where we had given equal rights to partners of South Africans who had gone abroad, come back with their partners, were gay, they couldn't, or lesbian, they couldn't marry. The same immigration rights that ours would have. We had a judge, Albi Sachs, been very active in the struggle. She wanted her partner, lesbian partner, to have the same pension rights as her male colleagues would have with their female partners. So we had quite a lot of precedent in South Africa. But the main thing was to say, if the state publicly affirms through the Constitution that same-sex couples have the right to express their intimacy, their love, their fidelity, their responsibilities, as heterosexual couples have, that is guaranteeing them their fundamental rights. That very same Constitution guarantees the rights of faith communities not to be compelled to recognize unions of that kind and recognize their autonomy, their independence within their own ranks. It's the one Constitution. And you have a coexistence between the secular and the state, and the sacred. And that comes from secular Albi saying how important religion is in our country in terms of schooling, music, health, in all sorts of areas of public life. Religious people are actively and openly as such involved. My colleagues all agree with me. But the question is, what should the remedy be? The Marriage Act doesn't overtly discriminate against same-sex couples. We can strike down the Marriage Act and you'd get a kind of equality. And one of my colleagues had picked up an article by an American professor, I'm not sure, don't remember from which university it was, speaking about equality of the vineyard and equality of the graveyard. If you get unequal treatment, how do you remedy it? You can remedy it by the graveyard. If gay couples, lesbian couples can't marry, then no one can marry. That's of the graveyard. And we would have got equality, and you can imagine the consequences. Heterosexual couples saying, these damn people interfering with our right to marry, which we've had for centuries. And gays and lesbians saying, what's going on here? As we reach the mountaintop, suddenly the mountain is pulled away. So we would have had equality of resentment. What we want is equality of the vineyard, where the project of the Constitution is realized, not simply taking away the discrimination, but realizing the actual enjoyment of the equality. I dealt with separate but equal. The danger was Parliament might run to separate people. Okay, we've got marriage for heterosexuals, and we'll have a civil union for gays and lesbians, and they'll get all the same rights in terms of property, in terms of mutual support, in terms of tax, in terms of inheritance, visitation, equal, no problem. And I drew on separate but equal in the United States. It wasn't only that it was never equal in practice, it had an assumption of superiority and inferiority, of clean and not clean, of mainstream and odd, variable. I also dealt with the issue of, so this made me think about how did the discrimination actually function? And what's meant by equality? Equality doesn't mean sameness of treatment. Equality means equal concern and respect for people across difference. If you say equality, if everybody behaves like Cecil John Rhodes, the great imperialist, used to say equal rights for all civilized men. And a civilized man would be a man, of course, and an English gentleman who would eat with a knife and fork and speak English, go to church on Sunday mornings. But that's not equality, that's sameness. In fact, it's the opposite of equality because you're forcing people to change who they are to enjoy equal treatment. And in South Africa, we had a case in the 1930s where somebody had complained about the fact in the post office you go to buy a stamp and they had separate queues for whites and for non-whites. And the judge said, where's the problem? You can get the stamp quite as easily from the one queue as the other. And only one judge stood out. I was interested to read. He was the author of our leading textbook on criminal procedure. And I didn't know he had this exciting past. He'd been to Oxford, he'd become a socialist, and in his dissenting judgment in this case, he'd said, this is really a question of dignity, and the reason you have the separation is not for convenience, it's simply to exclude people of color from standing the same line as white people. So this was to counteract any response being based on separate but equal. But then what should the remedy be? And my colleague Kate O'Regan said the remedy is simple, Albi. We just write the word into the Marriage Act. IAB, take you, CB to be my lawful husband, third wife, complete the sentence, start. Anybody? Anybody? Spouse, you got it. Spouse, gender neutral. Now, of course, spouses can say, meet my wife, meet my husband, men, women. But anyway, that would be enough. And Kate said, we've got to do it now. They have the right. No delay. The rest of us, however, wanted Parliament to be involved. We wanted a national debate on the topic. We felt that same-sex marriages would get much greater status as a kind of real equality if Parliament passed the law and if the nation had been involved. It wouldn't be seen as some funny little these liberal progressive judges out of touch with humanity. And I had the conviction that Parliament that had introduced sexual orientation as a forbidden ground of unfair discrimination, they would have to face up to the commitments they'd made then. And that was the issue. I was very pleased to read the Southern Council of Churches called the judgment opinion of Solomonian. My dad was Solomon. But in a sense, that was what I was trying to do. Not to, and I said it firstly, we don't draw a line between the benighted on the one hand, the bigot, and the enlightened on the other. it in a way that is telling and not. It amused me that Scalia, who happened to be a personal friend of mine, was amazingly proficient at telling the story from his position in a powerful, effective way. Great storyteller. He used that language so efficiently. For me, a colleague and total opponent, jurisprudentially, it was a terrible combination. I wish he'd been less skillful and more clumsy. In any event, so the majority of us took the position we would declare the restriction of marriage to a man and a woman to be unconstitutional, not because it allowed men and women to marry, but for under-inclusiveness, not for over-discrimination. And again, I picked up a lovely observation in an American article where you don't find a young man comes home, says, "Mom, Dad, I've got something to tell you. I'm black." So that would be where you're dealing with visible forms of discrimination, race, gender, generally, and so on. Here the discrimination is invisible. You render it invisible. And it's the under-inclusiveness that was constitutionally offensive. And we gave Parliament 1 year to make the correction. Now that's something we can do under our Constitution. When we drafted the powers of the Constitutional Court, it included the right to make an order declaring unconstitutionality, the duty to do so, where it finds unconstitutionality, but to suspend the operation of the order for a fixed period to allow the legislature to correct the defect. It's very, very useful that. You have a conversation with Parliament. It's not like you're enemies and it's all or nothing. If it's all or nothing, it's often nothing because the results are so catastrophic. So here we can say, you've got to do it, but
laws. They have their own special law. Like, yeah, they can say they're married, but it's still technically like a civil union. So what do you feel? Do you think it's just semantics, or it still goes to like them not having full dignity and them not being fully immersed into the law?
Okay, let me take those. I should have mentioned that we gave Parliament a year, and we said if Parliament doesn't find a legal remedy, then the word spouse will be written. So we didn't leave it open-ended, it was a compulsion. They didn't choose that route, but the Civil Unions Act was already going through Parliament. We had a long inquiry, and a fair number of people for different reasons didn't want to marry, but they wanted to regulate their legal relationships in the civil union. And this was in the heterosexual population, so that was already on its way through. It might be that this was a softer option, but the net result is that it's on the statute book, it was adopted by Parliament, and if the same marriage officers perform both, there's a very wonderful journalist, Mark Gavissa, was now allowed to marry his partner, and he described it. He went into this little office and he was very alarmed that the marriage officer who welcomed him in was a real old guard, white Afrikaner, unsmiling, and he saw funny things stuck on the wall, and he thought, uh-oh, I've come to the wrong place. And the minute the ceremony starts, this guy breaks into a big smile and said, I'd like to welcome you on this very special day in your lives, and a kind of homily. And it was a surprise because it came with the accent from somebody, and the smile and the warmth. And Afrikaners can be very, very warm in a more unabashed way than those of us growing in a more anglicized culture where you kind of hold back on your enthusiastic expression. And then after they'd exchanged the rings, he said, and would you mind very much giving me the box? You'll see on the wall I put up the boxes of all the same-sex couples that I've married. And Mark was delighted. It was a little South Africanization, if you like, of the whole process, but he felt very, very welcome. In the decision that I wrote, I actually said that Parliament might consider a clause which would allow marriage officers who had genuine religious objections to performing same-sex marriages, to allow them to be exempt. And I had three reasons for putting that in. The main one was strategic. The concern that a marriage officer would dig in his heels and fight on this issue, and that the whole issue of what's at stake would shift from the right of same-sex couples to express their love openly to the rights of conscience of the religious officer. And it would become divisive, and people would be rallying around that, and the public education would be diminished. And when the Pope came to the United States, that's exactly what happened. You remember in particular case, just to avoid that, it was partly strategic. It was partly, for me, the idea of being married by somebody who's loathing the ceremony. I just felt that that's awful. But also partly because I fought for my right not to pretend religious belief I didn't have so much. I'm very respectful of conscience. This year now, this last year, Parliament withdrew that exemption. And I think they withdrew it because our country's got used to it now. And it's not bizarre or strange. And what becomes bizarre and strange is the marriage officer who won't go along with the new values. So often these things are a question of timing. I would have said, for example, going for confectioners, bakers, or florists who refuse to provide goodies for same-sex marriages. It's a question very much of timing. When is the good time to bring the issues, to force the issue, when you simply rely on boycotting firms like that, I don't know. But these are strategic questions, and judges can have, and litigants can have different views. In terms of the multiple forms of family in South Africa, the courts have never been called upon to consider whether polygamy per se involves discrimination on the grounds of gender or whatever it might be against women, because you don't get, the joke is made, how many husbands would a man have? But that's used as a kind of joke to get away from the real issues involved. But where our court has been quite active has been where it's been more in Muslim marriages than African marriages, protecting the interests of second, third wives, saying we don't take a stand on the issue of polygamy, but we do protect the weaker parties in the particular case, and so we will ensure that they're given some kind of equal treatment in terms of maintenance and on the breakdown of marriage. I forget, you had another question.
Yeah, so, one of the surveys, Afrobarometer, looks at public attitude.
Yes. Well, I think I answered that.
Yeah, I think you did.
And I think also what made a difference, it made a big difference here when people started coming out. And it's somebody you've been working with for years. It's your nephew, it's your sister, your neighbor, your friend, the person you play football with. They're coming out and acknowledging, or just living openly as gay people. I think there was just a wave of that at a time, I think, that was very, very significant. I don't think the judges are so crude that they look at opinion polls but there's something it's strongly in the air, and it's part and parcel of the judicial function to not just read the books. As long as what's in the air is for humanity, for dignity, for equality, for justice, then I think it's quite appropriate to allow that to have an impact. Let me put it, I won't put it stronger than that. Not to dictate your reasoning, but to have an impact on your reasoning. And I'm really proud as a South African that we were the 5th country in the world, the first in Africa, to, I think we're the first country, maybe even the only country in the world, to have sexual orientation in the Constitution, the text of the Bill of Rights. And this was taken not because we had a powerful equality movement, LGBT movement. We've got quite a strong movement. It played a role, but because it was the women's section of the ANC, while we were still in exile, that took a stand in favor of non-discrimination on grounds of sexual orientation. And that was just before we came back. That was a political stand they took, women inside the ANC. And once they'd done that, those of us working on the Constitutional Committee of the ANC could include it. Now, it's not Albi Sachs and Kala Asmal and whoever it might be who happen to feel strongly it's a question of fundamental rights. We're pushing it. It's now a decision taken by a structure of the movement. It's now part and parcel of the policy. Now we can run with the ball. We can move with it. So quite early on, we put that on the agenda. And then the strategy was start with decriminalization. That's the most pernicious, flagrant form of discrimination. Sodomy was a criminal offense. That was challenged in the court. We struck it down. And then to go for equality of treatment by the bureaucracy, pensions and so on. We had one case dealing with in vitro fertilization, which is particularly important for lesbian couples. We had an adoption case of a judge, a woman judge, whose partner said that she wanted equal parenting rights with her companion, who was the judge. And the adoption law gave special parental rights, in this case, to her as a single person. And her partner would simply, I don't know, wouldn't have equal rights. And the partner said, in fact, while Judge so-and-so goes to work, I'm the one at home looking after the child, and I want equal parental rights. I mean, I think it wasn't really a concern in the household. They wanted to make the point, the legal point, to win that case. So we were slowly building up a series of decisions, laying a platform. And each case we said, we're not dealing with marriage, because somehow that was such an emotional issue, it was so terrifying to some people. So step by step we dealt with these other areas, and finally we had to deal with marriage. We did deal with marriage. And it's, when I speak to people in other African countries, I don't use the language of bigotry, backwardness, and so on. People don't like to be called bigots, particularly if they are bigots, but even if they're not, even if they're not, that's the wrong, it's the wrong, it's the wrong discourse. I was very struck about 6 years ago. I went to Maine, and people were very excited there. The legislature had just adopted a law allowing same-sex marriages before the Supreme Court did. And they told me that they were very keen. They did a public opinion poll. They found that when they were speaking about the human rights aspect, 45% favored equality, 55 were against. They changed the whole discourse to move away from human rights to love. To love. If people love each other, and they have to be the same sex, and they want to show public commitment, should they be prevented from doing that? And just changing that discourse helped a lot of waverers at a time when people were coming out. And in that sense, it's very similar, if you like, to the approach that I've been following and my colleagues have been following in South Africa. It's a hard battle, and what doesn't help at all is there are evangelists from the United States who are losing the battle here, and they go to Africa, and there they get a right on, they're cheering and so on, and they put money in there, and they introduce personalized attacks on people, not just gays and lesbians, but people who support equality in a very, very vicious way. It's an ugly form of internationalism that is anti-people's rights.
Other questions? Just put up your hand. Can't believe we don't have other questions or comments.
Do you have a question?
I'll have to think of one.
You say I do?
Yeah, there's one here, and I'm thinking of one.
Hello, Andrew Regent, College of Law. Once again, thank you for coming out. MSU really appreciates you coming here. My question had to do with, you gave Parliament a year and the involvement that the court, when they invited Parliament to come in, is that something that typically happens? In your book, you had mentioned that to rule unconstitutional the Marriage Act would be silly, but also there's the idea that to invite Parliament in to help make the solution, you're legitimizing the law, as you discussed. Not being well learned in the nuances of South African constitutional law, is that something that happens frequently? Is that a very rare event, or is it just because
No, all
of
the
their
time.
Okay.
All the time, all the time. we had a whole series of cases on reverse onus of proof, going against the presumption of innocence. Certain facts are found, then the defendant has to prove on balanced probabilities that he or she is not guilty. You've got the stolen goods in your possession, you've got to show. And we felt that violated the presumption of innocence, but we didn't want to strike it down completely. So we introduced a form of terminology that was reading down the statute to say it's too wide, but you can call upon somebody in possession, found in possession of stolen goods, to at least raise a reasonable doubt. You can't just remain silent. You must at least raise a reasonable doubt. But if at the end of the day, we don't have juries, so the trial judge says, well, I think you're guilty, but I'm not sure, then you must be acquitted. And so we would find a kind of language that would have to be read into the statute. Sometimes we use severance, you cut out words. I think that's probably done here as well. That's for non-lawyers. You cut out the offensive words and what's left is okay. Reading in is much rarer, because that seems like intruding on the legislative function. But we've done that. But we do that only when it's very clear, it's very simple, and we do that to save a law. If you don't have it in, the law is unconstitutional. The whole thing has to be done again. And if it can be saved by simply tweaking it, reading in an extra word, in this case spouse could have been a way of doing it, with no major budgetary implications, then the court will do that. But the normal thing is to say we declare that provision to be unconstitutional, but to strike it down before something is done to replace it is too drastic. There'll be chaos. You'll be scared to strike it down because of the implications. We give Parliament, I remember one case we gave Parliament 4 years. That was the question of adoption, in the case of adoption, of an unmarried person, adoption of a child born into a married couple, the consent of the mother and the father has to be obtained. If the mother is unmarried, then it's only her consent. And a guy who'd been living with his partner for some time said that's unfair discrimination against men, because I conceived the child, I want to have a connection with the child, and I'm being excluded. His particular case was not all that meritorious, and even if the consent is not given, it's not binding, but at least has to be sought. So in that case, we had to think about cases where a woman's been raped. Now she has to go and ask the rapist, who might be in prison, for his consent. That was very hard to imagine. Or a case where the person disappeared. You've got to spend weeks and weeks and money to try and get hold of that person, and adoption needs to be done very, very quickly. It would be inappropriate. So there are cases of meritorious fathers, and Ismail Muhammad, who wrote the judgment for the court, mentioned Muslim marriages are not recognized. Although they've been solemnized in a very serious way, great meaning with the community, but that would mean, in the case of a Muslim marriage, in technical terms, only the decision, consent of the mother would be required. He wanted to make sure that Muslim marriages were given proper recognition. So we said, we as judges can't determine who the meritorious fathers are and who are not. That's something Parliament has to do. And it has very big implications. It's a very sensitive area that requires great caution. They mustn't rush in. And I think we gave them at least 2 years when we asked them how much time they needed.
So that form of parliamentary constitutional review, is that written into your constitution, or is that just through precedent that you guys have set?
No. It's clear in the Constitution, the power of the Constitutional Court. It's not a power, it's a duty. If a case is properly brought, and we have very wide standing, and the court finds that there's constitutional violation, you can't say, oh no, this is too tricky, or we don't want to handle it, or there's some kind of presidential prerogative. We've got to declare. But having made the declaration, we have to make an order then that's just and equitable, and it can be simply a declaration striking down the law, or we can suspend the striking down of the law for a certain period. This is in the Constitution, giving Parliament opportunity to remedy. And it's actually very good for the separation of powers, because it encourages dialogue. It encourages Parliament to think about their duties, but the court also to think about the remedy. And then we'd ask Counsel for Parliament to tell us, how long do you need? And they'll say 18 months. You might say, no, that's too long, 12 months. Then sometimes the 12 months pass and they come back to us. They say, we really tried hard. We just haven't been able to get all the information we want, get it through all the procedures. Can you extend it? And very reluctantly, we're always very reluctant to extend, but we always do extend.
Thank you.
There are lots of things in our Constitution that I think are models for the world, not just substantively, but the whole road of the Constitutional Court. We have social and economic rights are very strong. We have to rule on them quite often. Strong environmental rights.
I have a question as well. Again, thank you for coming here. My question was, when you were writing this decision, did you have foresight to see that this was going to be the reasoning and rationale potentially for, I know this case was cited by the Indian Supreme Court in their recent decision to legalize gay marriage, that giving a framework, a legal framework to the non-aligned, going back to your 1948, whether it be non-aligned or African countries that want another reasoning and rationale other than Western democracy, whether it be United States or Europe, kind of dictating to them how they should choose their policies.
We were very aware that we are an African country, African majority. Majority of people in their homes speak African languages. And we use the concept of Ubuntu now increasingly in our reasoning. And it's an African cultural, philosophical, spiritual term of human interdependence. I'm a person because you're a person. I can't separate my humanity from acknowledging your humanity. It's the total opposite of the atomized view of human beings. One of your judges spoke about the right to be left alone. It's the greatest of all liberties. And for me, it's, you're dying of hunger, but with your last breath, you can curse the government. That's the epitome, if you like, the quintessence of the American vision of the isolated person, but you can shout it out loud. The Ubuntu notion then presupposes interdependence between people, that we live in communities, but it also means I must respect your individuality. So it's not contradicting individuality. It's not an extreme communitarian approach that suppresses autonomy and choice and individuality. On the contrary, the assumption is that I enhance my personality by being involved with your personality. And we use that quite extensively. When we abolished capital punishment, that was done judicially. Out of the 11 judges, I think 5 of us used that term Ubuntu in some way or another. The African countries, we have sometimes quite a complicated relationship. I remember one of our leaders, African leaders, saying, we don't want to be the Yankees of Africa. Sometimes there's, particularly the authoritarian leaders, reject Mandela, reject the whole South African approach, and they would be hostile to recognizing same-sex relationships as a kind of an example of You know, we're not like those crazy South Africans. But many people come to live and study, work in South Africa. They see we have huge problems, serious problems. But they dealt with politically. They open, they go to court. The courts stand up to the president, to parliament, have become very, very important in South Africa and very popular with the masses.
I think that we're just at the end of time.
Were you going to ask something?
I was going to ask something, but I think it's a big question. Let me try to frame it. In the title for this talk, you talked about making a comparison between the South African court and the US Supreme Court. And some of us have been concerned with the latest appointments that our Supreme Court may be leaning towards divisiveness or division, that some divisive issues seem to be framing selections. And I just wondered, how is it now in South Africa? Has your unity vision held, or are you seeing more divisive tendencies in this way?
No, I would say from the beginning, we were all people who had fought against apartheid in different ways. And our constitution, when I had lunch a couple of years back in the Supreme Court, the food was lousy, the conversation was fantastic. And I must say the Chief Justice was a very, very gracious host. And Justice Alito said to me, Justice Sachs, would you say, I'm not going to try his accent, that the South African court is an activist court? And I said, yes, Justice Alito, but we have an activist constitution. So we are of that same generation. We are the original intenders of the Constitution. And I might say in passing, I don't even remember what we had in mind when we drafted. We went through so many drafts and changed so much, and the context changes so much that we would never use original intent, even though we were the original intenders. And we would see it as a living tree. If anything, we'd say our original intent was that the Constitution should be a living tree. That was our intent. So we came from very different social, cultural backgrounds. A few of us were non-believers, majority believers, and totally different personalities, some extrovert, some very quiet, very, very different philosophically in many ways, but all agreed on the need for transformative constitution. A need to look at land law not simply with the old technicalities of real estate, but in the context of enormous dispossession. The phrase, possession is 9 points of the law. I wrote dispossession was 9 points of the law in South Africa. So we had to understand and interpret the law in keeping with that. So the change has been more in our complexion. When we started, it was 11 judges. I think 6 or 7 were white, all except one men. And now it's overwhelmingly black people. It's 3, I think 4 women judges. And it's been a kind of continuous, almost seamless evolution. When we began, we had nothing, no precedent. We couldn't use the precedent of the apartheid era. So we looked to international law and international legal practice. And we were given copies of Larry Tribe's book and a book by Alec Hogg from Canada by the respective embassies. So it was quite easy. You would just go, look up the topic, go into the index, look at some of the cases. I'll mention the 2 judges I found I was citing the most. Who do you think they were? Now this would be in the late 90s. 2 US Supreme Court judges. I didn't look for their work to cite it. I found the way they put it was particularly trenchant and useful in understanding our Constitution.
Ginsburg.
Any guesses?
Ginsburg? Ruth Bader Ginsburg?
No.
Very nice.
She's my best friend on the court now, but she's not a great quotable judge.
Scalia, you said you loved
She's,
Scalia.
I would say, generally right and good and forceful and a terrific personality. No.
Rehnquist? Rehnquist?
Rehnquist.
Yeah.
Rehnquist.
Kennedy.
No, not even close.
Yeah, I was just talking about their ideas, I was talking about their way of writing.
I see, for
Yeah.
clarity, right. No, but also the philosophy,
Uh-huh.
supportive of
Yes.
Scalia.
Anthony Kennedy.
Anthony. Warren. Must be Warren.
Stevens?
No. Okay, Gela?
William Pryor?
Yeah, Douglas.
Yeah, Brian.
No. No, Brian wasn't
Blackman.
writing,
Oh.
it hadn't been all that long. Anyway, it was Brennan. And I just found,
Left.
I'm reading the text in the textbook, and wow, that's strong. Yeah, I like it. Yes, that's what I want to say. And it would be Brennan who said it. And the other was Robert Jackson. And he's coming to the news recently in the case he wrote on the appropriation of the steel mills during the war, the Korean War. And I found a beautiful judgment. He like stepped out. He wasn't just playing with a few words and pushing. It was like locating the issue in terms of a large vision, with very crisp, very strong language on the presidential powers and limiting those powers. In any event, so in those days we used their decisions, and then more and more I discovered we were citing the minority. Brennan now in the minority, Thurgood Marshall in the minority, Harry Blackman in the minority. But that hasn't happened with our court. Its whole relationship is different. And if anything, our court has become very active in upholding the Constitution. If I can say so, I'm going to say so. The most activist court, I've known two very activist courts in my lifetime. One was at the beginning of when I was a law student, and that was the Warren Court. And the other is the current Supreme Court. It's very activist. It's striking down laws. I was going to say left, right, and center, mainly left and center. It's for me, it's activism. If Washington, D.C., on the spot passes laws limiting the use of guns, and the Supreme Court says, no, there's a fundamental right to own guns, and we've got to scrap those laws. That's very activist. If there's a bipartisan measure supported by Democrats and by Republicans in Congress to limit the use of money in affecting elections, to uphold democracy, the court strikes that down. You can do with your money what you damn well like. That's activism, as far as I'm concerned. When laws were adopted in the 1960s to protect the vote from suppression, and they are struck down on, as an outsider, it's a very dubious basis that now they're somehow irrelevant. That's activism. So it's not which court is activist. All the courts are activist. It's on which side are they activist. So if you're activist on the side of upholding money, power, property privilege, the rights of employers, the wealthy, that's not called activism. You're striking down laws, that's activist. You're intervening after the legislature, on the spot, has taken a decision. That's activism. If you strike down laws because women are being given a raw deal, immigrants are being treated in abusive ways, prisoners are denied elementary human rights, now that's called activism. And it is activism, but that's activism on which side are you being activist? On the side, the powerful, the rich, or on the side of the marginalized? And we speak all the time in South Africa in our court because the majority of our people suffered so much under apartheid and are still suffering from poverty, from hunger, from homelessness, from joblessness, and so on. The whole thrust is in helping protect, in a dignified way, the rights, the human rights, in a profound sense, the human rights of people. The wealthy don't need the court so much. They've got their money, they've got their power, they've got their connections, they can travel, they can move. It's the poor who need rights. That's been a big change in my thinking over the years, from being very skeptical about rights, seeing rights as something that's used and manipulated simply by the wealthy, to seeing how important rights are and can be for marginalized, for discriminated against people. And I would say I'm not just Albi. I might have slightly more flowery language than most of my colleagues, but I'm speaking for our whole court. That's the language, that's the discourse, the diction, and I must say it's one that's become very, very well received in South Africa. Our first case was striking down capital punishment. There wasn't dancing in the streets. It wasn't popular. If they'd done a survey then, it would have been in favor of retention. But they respected us for giving our reasoning, for motivating, and for standing by our views, and not for aiming for popularity. It even becomes a virtue in a court if you are trusted. And I like to feel our court is trusted. I'll just finish with this. People say, Albi, do you ever go to the Constitutional Court? And I say, yes, I go there from time to time. And I'm thrilled to see how well they're doing, and dismayed to see how well they're managing without me.
Thank you so much. It's wonderful to have you here with us. If you would like to join us again tomorrow afternoon, 3:45 to 5:15, third floor of the law school for the reception. Thank you all very much for coming. And thanks again to the law school for bringing Justice Sachs back to MSU. Thank you.